Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director of Washington Legal Foundation, as well as the head of our Legal Studies Division. I appreciate everybody joining us today. We're going to have, I think, a really interesting program today on the Albertsons and Kroger merger. So consolidation in the realm of retail, and in particular between grocery store chains, has been kind of a common occurrence over the past several decades. It's certainly not one that's been overly controversial. These are uncommon times, however, where food prices are straining budgets and very active regulators are in charge of government agencies. After a lengthy investigation, this past February, the Federal Trade Commission filed a lawsuit to enjoin Kroger's purchase of Albertsons. We're pleased to have with us today two attorneys with a wealth of experience, both from their time at FTC and in private practice, to discuss the merger challenge and its broader implications for merger review and enforcement. I'll introduce our speakers first, and then we'll get started. Maureen Ohlhausen is a partner in the Washington, D.C. office of Wilson, Sonsini, Goodrich, and Rosati. In 2012, she was confirmed by the Senate as a commissioner of the FTC, and she was appointed acting chairman in 2017, a role she held until May 2018. Prior to that, she was director of the Office of Policy Planning at the FTC. She's a recognized thought leader, frequent author, and speaker, quoted in print and broadcast media quite often, and most important to WLF, she's a long-serving member of our Legal Policy Advisory Board. Thank you for joining us today, Maureen.
My pleasure.
Michelle Yost Hale is also a partner at the Washington, D.C. office of Wilson Sonsini. She regularly appears before the FTC and U.S. Department of Justice, representing companies across a range of industries. Prior to joining the firm, Michelle served as lead attorney, and I hope I'm saying this right, in the Mergers IV division of the FTC, where she led matters related to the healthcare, supermarket, and retail industries. So we're recording this program today, and if you have any questions for our speakers, please use the Q&A function located in the Zoom webinar toolbar to ask any questions. So Michelle, we'll start off with you. Can you give us a brief description of the two merging parties here and their stated reasons for wishing to combine?
Yep. So thank you so much for having me. And I'll give a brief description of the parties and what I understand their reasons for wanting to combine. So Kroger is a retailer that operates about 2,700 supermarkets under numerous banners in the U.S. Some of those banners are Kroger, Fred Meyer, Harris Teeter, King Soopers, Mariano's, and they operate across 36 states. Kroger has largely expanded over time through acquisitions. It employs about 430,000 workers and is a party to 300 collective bargaining agreements. Union labor does comprise most of its workforce. The FTC alleges that Kroger is the largest supermarket retailer in the U.S. For its part, Albertsons, which the FTC alleges is the second largest supermarket retailer in the U.S., is also a union employer of grocery workers and operates approximately 2,300 supermarkets in the U.S. Its banners include Albertsons, Safeway, Hagen, Acme, Jewel Osco, Shaw's, Tom Thumb, United Supermarkets, and Vons. Albertsons has similarly grown by and operates a number of union operating stores. As to the reasons for the merger, Kroger's chair and CEO has publicly stated that the combination of the companies brings together two purpose-driven organizations to deliver superior value to customers, associates, communities, and shareholders. The parties have set up a merger-related website, if anybody wants to take a look. And that website notes a commitment to lower prices post-close by $500 million. It also notes that it will invest $1.3 billion into stores, $1 billion into raising wages and benefits for its associates, and donate 10 billion meals by 2030. So those are some of the benefits that they are touting.
Thanks, Michelle. So as I mentioned, the FTC took a pretty long review of the merger, about 18 months. Is that an unusually long period of time, Maureen, for reviewing the merger?
Well, merger reviews have been getting longer, particularly under some of the current leadership, because they are looking at a wider array of issues than maybe previous. Though some of the labor evaluations did start in the previous administration. But the parties did build this into their merger agreement, so they anticipated a lengthy review. So that wasn't, I think, a surprise to them. Also, given the geographic scope and the local nature of the markets involved, it, a longer review isn't totally surprising, because some other deals that, don't have that level of complexity. Here, you actually have, sort of an MSA by MSA, sometimes kind of approach, for grocery competition. Also, they tend to be intensely local. And so that often means state AGs are involved, which they conduct their own review, and so that can contribute to the length of an investigation. In this case, and I know we'll talk more about this, unions are involved, right? And that's part of the FTC's complaint here. So that can also contribute to the total length of an investigation. So that definitely, that made a recipe for, not the longest I've ever heard, but a pretty long investigation, but I think anticipated by the parties.
So there's been a lot of discussion and atmospheric sort of around this, not the least of which has been the price of food related to inflation, a lot of political pressure from Capitol Hill, lawsuits by Colorado and Washington. How much of that, Maureen, do you feel played a part in the FTC's decision-making process and perhaps the sort of challenge that they brought?
Yeah, so I think that obviously there's been intense focus on this, and we saw Chair Khan actually, I think, go out, I recall, at least to Colorado to meet with some interesting constituencies out there, paired up with Colorado Attorney General Phil Weiser. There have been, obviously lots of different political constituencies interested in this, the unions for one case. So I do think, and also the way this feeds into some of the administration's focus on food prices, just it puts a very, very bright spotlight on this acquisition. So I think it's kind of again, to use a food pun, a recipe for great political interest in what's happening. Now we can talk more about it, but look, part of the FTC's complaint is a very traditional kind of approach to competition in the grocery market. So I wouldn't want to suggest that this is purely driven by external to a competitive review concerns. So sort of remains to be seen how the evidence will stack up in court.
So Michelle noted some of the things that Kroger and Albertsons have committed to do in relation to the merger. Are those the kind of things that parties would usually do to try to fend off a federal government challenge here? Were there other things that you think they may have tried, and why do you think that those efforts didn't go far enough for the commission?
Yeah, so I mean, they set forth the divestiture package of stores, and they had an upfront buyer. Those are things that the agencies have been encouraging parties to do. And that also contributes to the lengthier review, right, to look at that proposed divestiture and the proposed buyer. They also have made some commitments, some post-close price commitments and commitments to not have layoffs. Those are the kinds of things that have the potential to ameliorate agency concerns. I think what we've also seen is that as courts have looked at mergers and merger challenges, and thinking about Microsoft Activision, for example, they have evaluated the proposed fix that the parties put forth. The FTC in those other cases has argued that the court shouldn't consider that. It should just be the merger, kind of standing on its own and not looking at a fix to it. But so far, the FTC has not been successful in convincing courts of that. That issue is on appeal right now in the Ninth Circuit. But even in Illumina Grail, where you could say the FTC, had somewhat of a victory, the court there, the Fifth Circuit also held that the deal needs to be evaluated with the proposed fixes. I think they have done the kinds of things that one would anticipate and suggest that they do. I know, they've made commitments. They've tried to, address concerns by a lot of the different parties who have raised concerns about the deal. I think, they've done everything they can to try to get the agency comfortable. Now it's kind of up to the court to decide.
There's a couple of different issues we want to get a little bit more into. One of them is always important for a horizontal merger case, the relevant market for this challenge. Michelle, how does FTC define the relevant market here, and how does it sort of set up a situation where, under the recently amended horizontal merger guidelines, the market concentration that sort of comes out of their relevant market definition exceeds the threshold and puts this challenge into sort of play?
Yeah. So the FTC has defined two markets here. So the first being supermarkets and the second being local CBA areas, but the principles are kind of the same. On the substance of what a supermarket market is for antitrust purposes, it's really premised on this notion that consumers can visit a supermarket for one-stop shopping versus, having to do multiple shopping trips to meet all of the consumers' weekly household needs. The way that the FTC considers a supermarket different from other types of markets where one may shop is that it has about 10,000 square feet of selling space for food and non-food products. And then if you look at the complaint, it has a veritable laundry list of what a supermarket carries, which we all know what a supermarket carries. Importantly, the FTC's market does not include club stores like BJ's, what they so-called limited assortment stores like Aldi and Lidl, Trader Joe's, or premium natural and organic stores like Whole Foods, dollar stores, or e-commerce retailers such as Amazon. As Maureen mentioned, grocery retail is hyper-local. So depending on the population density, talking about really local markets with a radius from the store. I haven't sat and tried to calculate all of the overlap markets here or looked at size, but the complaint alleges that the acquisition is presumptively illegal under the new guidelines, and that would mean that the HHI exceeds 1,800 and the merger increase. So that's lower than the old guidelines, which have been codified into law. And this would be for overlapping local markets surrounding more than 1,500 Kroger and Albertsons supermarkets as denoted geographic areas. Frankly, I'm not sure it would make a material difference whether you examine concentration under the new guidelines or the old guidelines. In deals where competition is determined largely by these local geographic markets, like it's really a very fact-intensive inquiry that is very takes a lot of resources to kind of get down to the bottom of it. And really in those deals, it only takes finding one market to be problematic to find an issue with the deal, right? So when we're talking about the size and the scope of this particular deal, finding one market, it wouldn't be hard to find. But that's why these deals are normally cured by a divestiture package like the one that the parties set out in the so with respect to the local CBA markets, I think really when you think about the FTC's product here, you're thinking, and the geographic market, you're talking about local, very local supermarket, only supermarket competitors included in these kind of hyper markets around where the consumers.
So the market definition would include the grocery stores within like Target or Walmart as well, or are they not part of the definition?
Target, it depends. uh, as Ohlhausen like to say, it depends. It depends on whether Target has kind of a store within a store. Walmart has largely been accepted to be a supermarket by the FTC if you look at the FTC's precedent, because its supercenters have a store within a store. But
So-
that is kind of a live issue.
So some commentators have noted that this traditional supermarkets and supercenters definition has been the same since the 1990s for the A-Hole Giant merger. Has the perspective, is that outdated? I mean, can the parties argue that consumers shop very differently today in 2024 for groceries than they did back then, or even maybe just 10 years ago?
Yes, I am so glad you asked. I would say that the one-stop shopping premise is both outdated and untested. And I, as an antitrust grocery nerd, am sitting on the edge of my seat to see how this plays out in litigation. The fact of the matter is that consumers multi-home for groceries and household products, and that's demonstrated clearly through data, whether it be consumer surveys of shopping habits, by examination of any banner's average product basket size and scope, by all of these stores' razor thin margins, by the proliferation of different formats of stores that specialize in different types of goods but carry the same products as each other. And so this market also has the benefit of really good sense because all of us are grocery consumers. So I know that my family shops at no less than 3 different stores a week, and that these stores can and often are very different on a week-by-week basis. And by the way, I'm not including in that statement, I'm not including the grocery and household goods that we buy on e-commerce. And that has certainly increased since the pandemic. And I have 2 kids in diapers. So we're talking about a lot of my household spend going to the e-commerce channel. All told, neither my local Giant nor my local Harris Teeter are serving all of my family's weekly grocery. So because my dollars are going elsewhere, this additional kind of chipping away at the traditional supermarkets already thin margins. So the other feature that I think I can't wait to see how this all plays out in litigation is that antitrust grocery wonks, we love to talk about natural experiments. So we're often able to examine local markets, see what is open or closed and what effect that has had on different stores in the local market. Love to look at all. It would really be interesting to see how shopping changed post-pandemic. I mean, I know our habits have changed anecdotally. And so I think that is something that the defendants can play up. And by the way, if anybody's listening that wants to endeavor a study like that, let's do it.
Maybe the first time that the parties in a merger challenge will try to figure out what the judge's shopping habits are as that goes forward.
Absolutely.
Maureen, how has the FTC fared in situations where they've gone to court to find a relatively narrow market? Are there precedents out there that might sort of show the way for Kroger-Albertsons here in opposing how narrowly the market is drawn?
So as Michelle noted, this relevant market really hasn't been tested in some time. We're kind of looking back in time to some precedent that didn't reflect the huge growth of online shopping, online acquisitions, and some of these newer formats coming in and really taking, I think, a large, share of, what we might have previously considered, just being served by the traditional grocery market. So if we look back in time, like to the Whole Foods case, the FTC's Whole Foods case. So on appeal, the court did accept the FTC's market definition of a premium natural and organic supermarket at that time. I don't know if that market would hold up today, right? Because we've seen traditional grocers really expand those kinds of offerings. They've responded a lot to market demand there. Certainly the pandemic really changed people's grocery shopping habits. And we'll see sort of the enduring effect of that. I was the chairman of the FTC when we allowed, well, we didn't challenge, that's what I should say, the Amazon's acquisition of Whole Foods, right? And that was a really interesting combination of an online provider with a traditional bricks and mortar premium natural and organic supermarket, right? So there's been a lot of changes then. And then also kind of stepping outside of the grocery area, the FTC did allege in the Meta Within challenge a proposed market of virtual reality dedicated fitness applications. It was an extremely narrow market definition. And look, there has always been, I think, this question of how narrowly you can define a market under the merger guidelines and under case law. But there, the court rejected that. And then they found a broad fitness market, noting that the broader market didn't exclude the existence of sub-markets. But I think, just because the FTC is alleging, like, back whatever 20 years ago, the market was defined as X, I don't necessarily see a court just accepting that. It's very, very evidence specific. And as I said, the market has really changed. Think about office supplies, right? You go back to office supply cases where the bricks and mortar sort of were really dominant, and now we've had changes in the market that the agencies have recognized over time. So it really will depend on the evidence developed.
Before we move on to the labor issues, labor market, Maureen, what you said, there's sort of a traditional harm to competition and consumers case within this. What's the harm that the commission alleges?
So sticking to just the traditional theory of harm on consumers and competition, and I know we'll talk more about the labor aspects of this. So they're alleging that it'll eliminate head-to-head competition between Kroger and Albertsons. That will lead to higher prices for groceries and household items for consumers, and that the loss of competition will result in lower quality products and services and ultimately reduce choices for consumers. So just focusing on the consumer impact, the very traditional type of harm. The labor discussion and impacts are the ones that are sort of the novelty, I think, in this. Putting it to one side, whether the FTC can prove its case, the theories that it's alleging are in that focus on just on the consumer side, the traditional ones.
So Michelle, moving on to the labor side of things, could you restate what the distinct labor market is here that FTC believes the merger will adversely impact, and why is that market definition being limited to unionized workers? Why is that significant?
Why is it limited to union workers? I don't know, and the complaint doesn't explain it. So the relevant market is local collective bargaining agreement. The complaint explains that local CBA surrounding the union grocery stores are another relevant market, but they don't really explain why. And the complaint says that Kroger and Albertsons survey wage and benefit information in these local areas to prepare for CBA negotiations. And that's because grocery workers prefer to work near where they live, which doesn't everybody. So it's not explicit in the complaint, but this market necessarily excludes non-union employment and union employment that is not grocery employment. So that's interesting. I don't know if it will hold up. I don't really know how one alleges or proves a hypothetical monopolist test in that market. But I think maybe what they are going for is focusing on the collective bargaining agreement negotiations for a second, the way that the parties would negotiate, or the way that the unions could leverage the parties off of each other. They view that as direct competitive evidence of this market, and would like to think that they don't have to allege a product market, because that's the way that they would like to do things. So that might be what they're trying to do here. And will be interesting to see how that plays out.
So the harm would be that by combining the two, you're depriving the unions the opportunity to sort of play each party off each other and to have higher wages and
Better benefits. Yeah, exactly.
right. So and from what I understood, the commission also believes strongly that unionized workers would want to remain in their jobs because of the benefits that they get from being a unionized grocery worker, that they wouldn't probably want to or have an opportunity to switch jobs to another industry, although there really isn't any barrier from them doing that.
Right. Yep.
Okay. Maureen, is there any judicial precedent out there on labor markets that the trial judge can be looking at, or that the parties are going to be citing to, or anything that can be argued sort of by analogy? This is a pretty novel theory, so definitely interested to hear what's out there.
Yeah, this really is a novel, relevant market that the FTC has alleged. Michelle mentioned the FTC may want to just say, oh, we don't really need to define the market because we're showing the anti-competitive effect. But that's always been something that people have been interested in trying to do. But judges, I think, have been pretty reticent to move away from that, because what we're looking at is the Clayton Act, right? And it seems to require a definition of a market there. So I think it's going to be, sort of a new, like kind of new arguments, new landscape the FTC is trying to create here. I think the court will want to look at, for example, what is the, significant, non-transitory increase in price, or, reduction in quality, those kinds of normal things that you measure, reduction in competition for, right? That's what the court is looking for here. I think it's going to be hard to come up with that because it's totally new. And then what's the competitive interaction for other potential sources of labor, right? Including non-union labor or other sources of union labor, right? There's a little bit of a fixed idea that you are a union, employee of a grocery store, and that, that's all you can do, kind of thing. So I think it's really going to be a challenge. Some of the things they might try to analogize to, I think, is the Apple eBooks case, right? Where they said, well, the authors were harmed, right? Or the authors more like labor, right? Than here. But again, that was not a merger case. I think it's kind of a attenuated analogy, but I think the agency is going to have to reach for attenuated analogies in their arguments here.
Jill, did you want to comment on that as well?
I agree with everything Maureen said. I mean,
I'm sorry, go ahead.
I think that the complaint is kind of thin on. You don't see the level of robustness that you do, even just comparing it to the way that they've defined the supermarket relevant market, clearly explaining what's in and what's out. So I think it will be interesting to see how it plays out.
So would it be possible for a judge to find that there wasn't harm in the sort of traditional product market for the merger, but find harm in the labor, or vice versa? Does this kind of give the FTC two bites at the apple here in terms of enjoining the merger?
I don't think so. I think you have to find harm in the supermarket market in order to find harm in the CBA market.
Okay.
Yeah, because even the way that the CBA market has been alleged is very tied to the local nature of the grocery store competition. So it would be hard, if the judge can't find harm in supermarkets. I can't imagine that they would, and go out on a limb on this novel relevant market. And but there could be a significant delta, because really what we're talking about is the FTC says around 1,500 Kroger and Albertsons stores, but let's say that's 700 overlap markets, because you wouldn't necessarily, it's not 1,500, right? And then the judge finds that for there's only really 100 where there's kind of a live issue, or the concentration is problematic, and then of that 100, there's only a handful that are union markets. I mean, you could kind of see it chipping away that way.
So the third area we wanted to touch upon today was the issue of divestment. So Kroger and Albertsons have offered a plan to divest a considerable number of stores to a competitor as part of the merger. Michelle, can you describe the plan and the parties' sort of justification as to how that divestment dispels competition concerns?
Yeah, so often when you have a deal like this, any deal where you could kind of an asset what the components, you want to plan for that as you go into the investigation, and that's clearly what they plan for here. It's implicit in the merger. The parties plan to divest approximately 400 stores under 3 banners to CNS Wholesale, the wholesaler that supplies a lot of grocery stores, but they also operate a number of retail, which is a relatively new venture for CNS at this point in its history, but by all public accounts seems to be successful so far. They will also be divesting 8 distribution centers to prop up those assets, and 2 regional headquarters, as well as 5 private label brands. So it's a pretty robust package. Again, I haven't done the local market analysis to see whether it would really cure what the FTC would allege to be problematic here. But it is historically the case that in these larger grocery deals, that the parties in the FTC will kind of as part of the investigation, investigate those assets and the buyer up front to assess, whether those assets would be sufficient to remedy the competitive concerns that the FTC is likely to have, or that they do have in the course of their investigation. And then they work that out, and they continue to kind of hash back and forth the different markets where those are an issue. Here, the fact that the agency has kind of rejected that whole clause is an interesting feature. I think one thing to note is that it potentially is because the collective bargaining agreement relevant market, that no divestiture can necessarily replicate that lost harm, or that harm that the FTC is alleging, the loss of competition. So it will be interesting to see how the fix it first plays out in litigation.
Maureen, the FTC had some pretty strong substantive objections to the parties' divestment plan. How strong do you feel those arguments are, at least in terms of how they may fare in court?
Yeah, so look, the FTC has been generally resistant to taking, divestiture packages as a remedy, right? They've taken some, but they raise a lot of questions. So here, they are claiming that this proposed divestiture is inadequate because CNS, who the proposed divestiture buyer, wouldn't acquire an ongoing business operated today in any geography. So that's one of the things that the agency likes to see, is that it's sort of like something that is already operating well in a unified way, and you're just sort of bringing that whole operating entity, adding it on. So they're saying that that's not happening. The FTC is alleging insufficient assets. So in many overlap markets, CNS won't be acquiring any stores. And in many divestiture markets, the FTC alleges defendants can't show that the divestiture will remedy the competition, lost competition. And so one way to interpret that is that the FTC is saying in many markets, the parties aren't offering the crown jewel assets, right? One thing in the complaint, the FTC talks about cast off, right? I haven't seen that term really used before in a complaint, cast off assets. So the FTC is concerned that ongoing entanglements with Kroger and Albertsons will compromise the divestiture. They believe, they're arguing that CNS is poorly positioned to operate the store successfully, and it's not a traditional operator. And so, grocery distribution, right? Operating stores also depends on a distribution network, right? Where you can service all the stores in a cost-effective way. And so it's, there's kind of it's not just, operating one store kind of standing on its own. And do they have the experience to do this? And in the complaint, they noted that CNS had at different times saying they weren't interested in expanding into offering, retail grocery services. One of the things that they talk about is that Albertsons had an unsuccessful divestiture before in 2014 and Hagen in 2015. And so there's a wider skepticism at the FTC about how divestitures fare, as how merger remedies fare at all, and divestitures. And so people often talk about the failure of the Hagen divestiture. Now, when I was at the FTC, we did a study to see if divestiture remedies could be improved. And of course, they can be improved, and the FTC, we recommended some improvements, kind of learnings from some of the divestitures that didn't work, including keeping the monitor who's monitoring the divestiture operation in the loop and reaching out earlier and sort of fixing some of the problems that were identified. But overall, that's the FTC's argument of why this proposed divestiture to CNS is inadequate.
So this had been sort of alluded to in the beginning that FTC would prefer the court not include the divestments and other potential remedies as a part of the prima facie case in making out a Clayton Act violation. Michelle, is that a position that where the government has prevailed in recent cases?
No, DOJ has not prevailed, and I think judges are highly skeptical. I don't think there's really an exactly apt case at the FTC, but DOJ tried this in United Change and in Asa Abloy, and the judge in Asa Abloy in particular was like, well, go settle this. Like carve out the thing that's the problem, and then they did. So I don't think it's very practical. I think judges are skeptical. Judges are busy, and they're not that interested in this kind of academic debate about the prima facie case, and particularly here where the divestiture has been a part of the merger agreement. It's clearly been a part of the FTC's investigation. They've been contending with it, for the entire lengthy, 2-year runway, almost 2-year runway that we've had on this investigation. It's hard to say like, okay, well, you should ignore that and let us prove our prima facie case, and then we'll deal with it. I don't expect that the court is gonna take the FTC side in that kind of academic argument.
So once again, if anybody has questions, please feel free to ask them in the Q&A box. So Michelle, we had mentioned at the outset, there's 2 state suits going on currently by Colorado and Oregon. What kind of unique challenges does this pose to both the government and to the merging parties in dealing with this sort of parallel state-federal merger litigation?
Well, so the FTC's case also they have, I think 8 state plaintiffs that
Right.
joined the case,
Right.
right? And Colorado and Washington have decamped and started their own cases. They're both facing motions to dismiss, so they have to beat that hurdle at the outset. And so I think that's the biggest burden for Washington and Colorado at the moment. For the defendants, just as somebody who has litigated a lot of these types of cases in the past, if the motion to dismiss is not granted, this is a major tax on resources to fight all 3 actions that are basically about the same thing. And that burden extends to third parties. And that's, really, I think, take very seriously in considering the motions to dismiss, because, having 3 bites at the apple in discovery for all of these parties, on a third party, it's a tremendous burden. These are really data intensive cases. It's a lot of information that they're going to be requesting of third parties, and that's a big problem.
Maureen, were there any cases like this when you were at the commission where there were separate state actions going on at the same time as the commission was challenging something in court? And it would seem to me that if there's an outcome in one of the state cases before the FTC case even begins, that's going to certainly paint public opinion on the case itself.
Yeah, I mean, what I recall is cases where the agency was bringing a challenge and the state AG was part of it, right? Was supportive of it, or just didn't take a position. So I don't recall ones where it was sort of not sort of marrying up. Now there was one where the FTC challenged and the state AG went the other way, and not surprisingly, we were not successful. The FTC was not successful in convincing the court in that case. Well, that was the hospital merger case, but yeah. So this, I think, is a little bit of an expansion of kind of coordinating with state AGs, where the agencies are sometimes, the state AGs are a little bit of the sharp end of the spear, more so than they used to be in the past. So we've seen it. We've seen it, but maybe not when I was there. But like the early Microsoft case, right? There was a lot of AG action there.
So what kind of a role do the state AGs that are a party to an FTC action like this, what's their role vis-a-vis the FTC staff and the others that are conducting the litigation?
Yeah, so I mean, they're focused, more on the local, right? The local issues for their local consumers. In this case, they're also focusing on the labor issues, which is again the kind of the novel thing. So yeah, I think that we're seeing also, I think, Colorado had an argument that the merger will harm food suppliers, so that wasn't reflected in the FTC's complaint. So they may also be exploring, a wider array of theories.
Right. So question for both of you to finish up here. What can businesses that are planning mergers or acquisitions learn from FTC's challenge here? Maureen, if you'd like to start.
Sure. So look, the agencies are in a very aggressive frame of mind. They don't want to, I think DOJ took a remedy in a case, today or something, but they generally don't want, they talk about sort of like a fix it first kind of approach, but where it's like all the competitive issues are resolved even before they bring the merger forward. They're very hesitant to take elaborate remedies. They have this view that those remedies put the risk on consumers, and that shouldn't be the case. So as much as it's a very good idea to, kind of come in with a belt and suspenders approach. You've identified, the assets you want to divest. You have identified the buyer. You're kind of coming in and saying, we fixed it, but be prepared to litigate, because the agencies, again, that same attitude of being skeptical of the effectiveness of remedies, and again, saying the risk shouldn't be on consumers.
Hale, any thoughts on that?
Yeah, I agree. I think that the posture here is just so very aggressive coming out of the agencies, hostile to remedies that, of course, like Maureen mentioned, things can always be improved, but for the most part, a lot of remedies have worked and are working and are continuing to work. So it's a little bit kind of talking out of two sides of your face to have this, to have like one bad experience and color the way that you continue to do business with the business community from the agency perspective. But yeah, I think really the tolerance for litigation or for risk protection really needs to be there. Kind of at the outset, you really have to do a lot. I counsel clients to do a lot of due diligence and to really prepare, identify, and analyze all the antitrust issues, and be really prepared to defend the transaction from day one and file with a full strategy to take you the distance that you're willing to go.
Seeing that we do not have any questions from the online audience, you were so convincing and clear in your statements that didn't inspire any further questions. We will bring this to a close. I want to thank both Michelle and Maureen for joining us today, and everyone who joined us online. For those of you who are online, when you sign off, a short survey is going to launch in your browser. We very much appreciate if you take a minute to complete that. It helps us plan future programs. Again, thank you for joining us today.
Thank you so much.